Let me just give it a few more seconds before we get started. Waiting for my special guest to join. Okay. Let me just give it a few more seconds before we get started. All right. So, when I did this, the last month in the circle meetup, right, in April, we had a special guest, one of my favorite people in the whole wide world. And a lot of y'all wasn't able to get the game that she came on and gave us. So what I wanted to do tonight is I kind of wanted to run it back a little bit tonight because the information is just so powerful. It's needed. And there's not a lot of people out here teaching it like my special guest. Like when I tell you guys at the Inner Circle Mastermind on April, I think it was that April 25th or something like that. When I tell you she taught for like 6 hours straight, and it was crazy. So I had to run it back, y'all. I had to run it back. TC, it was so amazing. And if you guys was there, they can tell you that, Shanice, she just came and she brought the fire for 6 hours straight. So I wanted to kind of run it back, right? I wanted to run it back tonight so that way everybody could get some of this information and we can have some good dialogue behind it because we all buying real estate and we need to be able to pass this down properly because the reality of it is none of us are going to be here forever, right? Yeah, Sam said it was very informative and she's an amazing teacher. That's a fact. So without further ado, like I said, I'm usually on camera, but tonight I'm not at the studio. So I'm not going to have my camera on because tonight is not about me. It's about my special guest. She's incredible. She's brilliant. She's a love of Christ, which I love more and more about her. I love people who love God. So, and she's just good people. She's just good energy. Like if you was there live and in person, you can see like how passionate she is about her subject and what she teaches and how she teaches it. So without further ado, Shanice, I'm gonna ask you to unmute yourself and I'm gonna pin you on the platform right now. Shanice Anderson, ladies and gentlemen, she goes by The Real Lawyer, Reel. That's how she spells it on Instagram, The Real Lawyer on Instagram. And when I tell you, she is so dynamic, she is fire, she is a lover of Christ, a mom, a wife, a serial entrepreneur, a real estate investor, an attorney at law. So she's not just speaking from theory, she's speaking as a practitioner, right? She has trust funds for the babies. She's all of that. So Shanice, I'm gonna ask you to unmute yourself right now. And I want everybody to throw some gems in the comments. Shanice, can you hear me?
Yes, I can. Can you hear me?
You have two windows open.
Yeah, I sure do. Hold on.
You have two Zooms. That's
Can
why we
you?
got
Is there a feedback still?
Is there feedback still? Let me see how you talk.
Is there feedback? Feedback?
No, but it's definitely, I see two names of you here.
Oh yeah. Because I'm gonna share my screen on my other computer.
Okay, no feedback at all.
All right.
I think we're good here.
Okay, just let me know.
All right. So let me set the tone for this right now, y'all, ladies and gentlemen. And I'm doing something that I normally don't do. I'm actually streaming this to YouTube right now as well. Shout out to the YouTube family. Shout out to y'all. For those of you on YouTube, you are in a treat. This is like an open enrollment tonight, YouTube, right? Normally, these type of things are behind the closed wall for my paid mentees. But I decided to put this on YouTube tonight as an open enrollment. So that way, I haven't been on YouTube in 3 months, Shanice. Literally.
Really? Oh my God.
I haven't been on 3 months. The last thing I put out on YouTube was February 11th. And I haven't been on YouTube. And I thought it was very important for me to put this information out on YouTube tonight. And then we'll do something later on in the month too on YouTube specifically. But I wanted to stream this to my YouTube because I've been neglecting my YouTube audience because I've been so focused on my mentees.
Yeah.
So if you're on YouTube right now, make sure you like this video, throw some gems in a comment, and I hope you guys have your pen and pads ready because Shanice is about to drop hella gems. And this is not going to be a 6 hour class, y'all. This is not going to be one of those. It's 8:11 now, and we're going to go to probably 9:30-ish. Okay, so Shanice is going to teach for about 45 minutes, and we're going to do about a 30-minute Q&A and try to answer as many questions as we possibly can. But I'm going to encourage everyone here on YouTube and with my inner circle, schedule your consultations with Shanice ASAP. You need to schedule your consultations because everybody's situation is unique to them. It's like your fingerprint, y'all. None of us have the same fingerprint. So a lot of the questions, she's not going to be able to do a deep dive into your question without knowing your full situation, right? But she'll do her best to give you, some game. But remember, she's an attorney at law too. So she has compliance that she has to follow. So I will highly encourage, book the consultations. It's worth every penny that you pay. Okay? And she definitely deserves the spotlight on YouTube and other things that I'm working on, Shanice, because like I said, she's dynamic, she's amazing, and she needs to hit big stages. So, with that being said, Shanice, I am going to take myself off the screen
Okay.
and I am going to just keep you pinned.
Okay.
And you got the show for at least the next, it's 8:15 right now. I'm gonna probably start Q&A around 9 o'clock, 9:05, somewhere around there. But I'll text you so that way you just have your phone close to you and or you text me. I'll text you like, yo, 5 minutes
Okay.
because I'm gonna wrap you up because I'm not going because I know you can go for 10 hours straight.
Text me, text me. All right.
So I'm gonna have to text you and kind of put you on notice and say, all right, you gotta relax.
All right. All right.
All right, y'all. So I hope y'all ready for this. Let's grow. Throw some gems in the comments. Shanice, I'm going to mute myself and
Okay.
the floor is yours.
Okay. Just want to make sure I can share my screen. All right. Y'all can see that?
Yep.
Y'all good? Okay. All right, perfect. Well, thank you guys so much for joining us tonight. Matt already gave an introduction, so I'll save time. But essentially, my name is Shanice Anderson. I'm an asset protection attorney specializing in business formations, LLCs, as well as trust and estate planning. So again, I'm an attorney at law, obviously, real estate investor, real estate broker, mom and wife, and I'm so excited to be teaching you guys tonight and just getting your legacy in the right place, right? Getting it nice and tight. So if you have any questions, please hold it until the end of the presentation. I'm going to try my best not to speed through it, but I know that I could sometimes be long-winded. So definitely write down your questions or maybe even drop them in the chat box so that I can go back and review it. after the presentation. So tonight we're going to obviously be focused on estate planning, specifically with a focus on trust, because estate planning is a very general, broad term that can include a lot of things, but we're going to really be focusing on trust and what is a trust, the types of trust, how to create a trust, how to fund a trust, why it's important to have one. And then we'll go from there. But before we go into kind of like a deep dive, I just want to introduce you to this framework that I use when I'm teaching, when I'm, sitting down with clients, and it's called the Nexus Framework, right? And I know it's hard to see on the screen, so bear with me, but this essentially is how, as you grow in wealth, as you grow in assets, you should not be thinking about one box, right? You are not contained to one box, especially for asset protection purposes. As you delve into the field of real estate, as you get children or have children, as you attain more assets, you need to be thinking about, where are my assets falling? Which buckets do my assets fall within? And essentially what this Nexus framework illustrates or demonstrates essentially is how to make your trust own everything. That is my mantra, is that your trust should own everything that you have: businesses, real estate, bank accounts, life insurance policies, retirement accounts, brokerage accounts, etc. And there are different ways to accomplish that and make sure that it does actually own everything. So if you see on the top left-hand side, there's a person that sits on the top of everything. That is you. And then you obviously have other people that are involved. For some people, it might be your spouse, it might be your children, it might be your parents, just depending on your circumstances. Then your trust holds various holding companies that serve different purposes. One could be a real estate holding company. One could be a holding company for specifically for your trading accounts. There could be a holding company for your business that holds other businesses. And that's really set up for asset protection purposes, right? So the left side is really focused on real estate, and then the right side of this chart is really focused on the different types of trust. When people talk to me about, hey, Shanice, like, what type of trust? Like, I need a trust. I don't know where to start. I want you to eliminate from your mind the lie that you only need one trust. Again, especially for people who are getting a lot of assets, attaining a lot of assets, you can have as many trusts as you want because they serve different purposes, right? And so there are hundreds of trusts. And obviously I don't have the time to go through all of them, but we'll touch on the ones that are most important and the ones that are most interesting. So this is called the Nexus Framework. All right. So as I taught in the mastermind, I think it was a month ago or a month and a half ago, there's this study called that NASDAQ performed. And essentially it highlights something called the third generation curse. And basically what this curse demonstrates is that if you look at the top, right, where it says you and your spouse, and that might just be you, it doesn't necessarily need to be you and your spouse, but for purposes of this illustration, it's demonstrating a spouse and yourself. According to the study, by the second generation, 70% of wealth will disappear. 70% of your wealth will disappear. By the third generation, 90% of your wealth will disappear, right? And according to the study, basically the reason for the third generation curse, and I'm going to write on the screen in a little bit, but the main reasons for this is one, due to lack of financial education, right? Not knowing how to manage your money, mismanagement of funds. But most importantly, more than anything, it's the squandering of funds. So when funds are passed down, when assets, when real estate, cash accounts, life insurance proceeds are passed down to your children or your children's children, especially when there are no parameters in place, it's likely that you will enter the third generation curse because that money will be squandered. It's not about if it's going to be squandered, it will be squandered, right? And then that's the second generation, and then that's the third generation, right? And a lot of the reason why wealth is squandered as well is because families can't agree. And I'm not trying to highlight a specific race or anything like that, but it's definitely more prominent among us, right? Among our people, is that we can't agree for nothing. There's always a sister against a brother, a sister don't like a uncle, and an auntie don't like a grandma. There's always family disagreements. In fact, I am in the middle of a litigation with a family, a father who had a will, left his house, his assets to his 7 children, and the sister that was appointed as the executor of his estate. Half of the siblings are good with her, and then a half of siblings don't like her. So what happened? Because it was a will, it had to go through the court system. And so the judge listened to the testimonies of the siblings that did not like her, and the judge overruled the father's wishes that made her the executor of the estate. And the judge said, you know what? I'm going to appoint an independent trustee, or independent executor, excuse me, an independent executor, personal representative is what they're called in some states, to manage this deceased man's estate, because y'all can't get it together. Y'all can't agree. So I'm going to take it into my sovereignty. I'm going to take it into my hands, and I'm going to appoint somebody that you don't know, somebody that doesn't know nothing about y'all, nothing about your family dynamics, and they're going to be the one to oversee your dad's and distribute his assets according to probate laws, right? And guys, they own their house. They have a house in Boston, and if anybody knows Boston, it's similar to kind of like New York City, where you have different boroughs. But their house has over $1 million in equity, and the appointed personal representative has put their father's house, contrary to their wishes, on the market to be sold. Right, to be sold against their wishes. I had to sit in the meeting. We have a court date on Monday. But basically, my point is, if you do not plan for yourself, if you don't take action, if you don't take the control now, the judge will, the courts will. They don't care about you. They care about making money. Because at the end of the day, everybody's going to get paid except you, except your heirs, except your beneficiaries. Everyone else is getting their cut. Probate court is getting their cut. The judge is getting his cut or her cut. The lawyers, they're getting their cut. And guess what? Your family's getting the residual, if any residual is even left over, right? After debts and all of that is paid. So I'm really here to encourage you guys to take matters into your own hands. And that's why I really like this quote from the What Would the Rockefellers Do? Make sure you guys go and get that book. It is life-changing. It's called What Would the Rockefellers Do? And in the book, it says you have the power now, right now, while you are alive, to make it so that your family doesn't have to start over every generation at zero, because that's what's happening. Every single generation, there's a reset of wealth. Every single generation, that generation is starting over from scratch. Why? Because the generation before them did not prepare, right? And so you have the power now, though, right? You have the knowledge now to do and to take action, because your ancestors didn't have the knowledge that they have now. Y'all sitting on the Zoom right now. There is no excuse for you to die in the grave and be like, oh yeah, I'm not going to do it because I didn't know. You literally have the knowledge on social media right now. I'm teaching this class on trust to take action now. So there's really no excuses. So let's talk about what will happen if you decide, you know what, I don't care. That's going to be somebody else's problem. That's going to be my children are just going to have to deal with it. That's not my problem when I'm dead and gone. So the first question, if you do nothing, so what happens if you don't exercise your power right now and you do nothing? What happens to your assets, right? So there's a kind of a flow chart that we have to go through, right? The first question is going to be, did you die with probatable assets, right? Do you have probate assets? If the answer is no, you have no probate assets, and we're going to get into a second, we're going to cover that in a second. What are probate assets? But if you have no probate assets here on the left, you're going to bypass probate, right? Your assets may not necessarily have to go through the court system. So that's a plus. That's an advantage, right? There's no court involved. But the disadvantage to that, if you look at the bottom under bypass probate, the disadvantage is there's an outright distribution, right? What is an outright distribution? That means that if life insurance proceeds, which are non-probatable assets, right? They bypass probate. If you have a beneficiary listed, your 18-year-old, right? Or your brother, right, is going to receive a outright distributions of $1 million if you don't plan properly, right? So that's an outright distribution. Now, if you have probatable assets, everything is frozen. Everything is frozen. I'm talking about your bank accounts. I'm talking about your investment accounts. I'm talking about that mortgage bill is still coming. That still needs to be paid. So if the mortgage still needs to be paid and your bank accounts are frozen, how is your mortgage going to get paid? It's not. It's going to go into foreclosure. That's why there are all these these estate sales. There are realtors out there that specifically look for probate deals, right? Because of situations like this. The family cannot afford to keep making the payments because they don't have access to your bank accounts, and the house falls into foreclosure. And that is how we lose our wealth. Because for most of us, or for a lot of us, there are two things that are make up our high net worth, right? It's going to be the equity in your home and your life insurance, right? And so you lose your home, then all you may have is your life insurance left over. But then now you got to pay out all your debts. You got to pay all these, your family has to pay all these funeral bills, all these burial bills. There's no planning that is happening, right? So everything is getting is going to be frozen. And then your family is going to literally have to open up a lawsuit in the probate court. That is what it is called. They're opening up an estate, but that's basically a lawsuit against yourself. You are opening up a lawsuit against yourself. Your family is going to have to pay probate fees. And in some states, that probate fees can range anywhere from 3 to 10%. Some states, there is a statutory set number or set percentage of what the probate fees will be of your estate. So if you know your estate is worth $1 million, some states will say there's a set percentage of 5% that will go to probate fees. Right. So there you go. Wealth is already disappearing. It's already decreasing because of these fees that are being involved. And then that's not even the worst part, right? You may be thinking, oh, well, $10,000 is not that much in contrast or compared to $1 million that my family will inherit. Well, that's not the worst part. The worst part is that the judge has to follow something called intestacy laws. These are statutes that are set by every single state. Every single state has them. And essentially, if you die without a plan, that's without a will, that's without a trust. If you die, you do nothing today. If you leave this call and you do nothing today and something happens to you, the court will follow the intestacy laws set by your state. Okay. And let's look at an example of what that may look like. I just happen to choose New York because that is where Matt is from, or that's where he resides. So I want you to take a look at the screen. And again, you can look this up in your state to see what your intestacy laws are. But this is New York's intestacy laws. Basically, this is what it says. If you die with children but no spouse, your children will inherit everything, right? If you die with a spouse but no children or grandchildren, so descendants is going to refer to children or grandchildren, your spouse is going to inherit everything, right? If you die with a spouse and if you die with spouse and children, right? So let's say you have a husband and you have children. In New York, it will get split between your spouse and your children. So your spouse is not going to inherit all of it and your children are not going to inherit all of it. They essentially have to share. So spouse inherits the first 50,000 of your intestate property plus 1/2 of the balance. And then your descendants, your children or your grandchildren are going to inherit the rest. But let's say you have no spouse and you have no children, you have no grandchildren, but you have parents. This is the scary part. This is really where it's more concerning than anything. Let's say you have parents, right? So you have a mom or a dad that's alive, but no spouse and no children or grandchildren. Guess what? Your parents inherit everything, right? And I'm going to talk about why that's so scary in a second. I want to get to this last point is let's say you have no parents. Your parents are not alive. The only people that are alive right now for you might be your siblings, right? Your brothers, your sister. And the law doesn't discriminate against who's a brother and who's a sister. If y'all should have the same daddy or y'all have the same mommy, I don't care. Half siblings mean nothing. They're still considered a sibling according to the intestacy statute. So that means that your siblings, right? That brother that you ain't talked to in 10 years, the brother that you don't like, the sister that you don't like, your sister or your brother will inherit everything equally, right? So going back to the parent section, right? Imagine you have a mother who raised you or a father who raised you. Daddy was never in your life or your mommy was never in your life. And because you died with no plan, your father, who may be a deadbeat father, is going to have a right to your estate, right? Is going to have a right to your estate, especially if you have no children in place. And you may be thinking, well, what if I never met him or what? They will find out. They will find out. They will find a way to get to the courthouse to claim their share. There are some states, I want to have a disclaimer. There are some states where basically if you can prove that like they never contributed to your life, essentially like basically they were a deadbeat, there are some states that will take that into consideration. But I want you to take a look at this prime example, Takeoff, okay? Takeoff died, obviously he was murdered. His estate was worth over $26 million, okay? Over $26 million. One, that's already an issue with taxes. Right now, you can pass away with up to $14 million. The number's like 13,900 something. You can pass away with that much estate assets, and not pay federal taxes. Okay. So there's an exemption that you get. Now, Takeoff estate was well worth over that. So he's looking, one, his estate is looking at a huge tax bill. That tax bill can run him anywhere up to 40%. 40%. That's damn near 50%, right? So that's half. Imagine $26 million being decreased down to $13 million. And I know you may be thinking, well, he still got $13 million, but that's $13 million or $14 million that went straight to taxes. That had he planned properly, the state would have got, the federal government, the IRS would have gotten zero had he planned properly. So there's a way to make sure that that amount of money does not get taxed. There are trusts that you can create and set up to make sure that your trust never pay, the assets that are in your trust will never be taxed, right? But that's not the worst part, y'all. The worst part is that Takeoff's daddy came out of the woodworks, right? He came from the wilderness and said, oh, I'm entitled, according to Georgia's intestacy laws, I am entitled to half of Takeoff's estate. Daddy was never in his life, never raised him in and out of his life. I don't know how many times he met him, but the mother, Takeoff's mother, objected and said, I raised him. That's my baby. I did everything for him. But again, the law does not discriminate. Again, there are some states that have specific statutes, but there is obviously a court battle between mom and dad to figure out, you know, is dad really entitled to this estate? So my point, what's my point? My point is that if you do not want your assets to go to people that you don't want it to go to, according to the states of your law, the statutes of your law, you have to take control now. You have to take control now because you can't speak from the grave unless it's written in a document. Okay. So let's talk about what happens to your real estate. If you were to pass away today, so I'm a real estate investor, own several properties, husband and I have primary residence, etc. If something were to happen to us today, right, or to you, this is a question that you need to be asking yourself. If something were to happen to you today, what would happen to your actual like real estate? Okay, so there are several ways that you can own real estate that you guys, you know, obviously know of, right? The first way is if you are on title alone. So just your name is on title, right? So if I go look up my house on the registry of deeds and it says Shanice Anderson, that means I hold title by myself. That means, so that's scenario number one. What happens if I pass away? What happens to my real estate if I pass away in scenario number one? It's a probatable asset. It's going to go through probate. So that means that my family will essentially have to go to court and petition and ask the judge, Your Honor, I imagine your children go or your loved ones going to the court, asking the court to give them back what's rightfully theirs. That doesn't belong to the court. That belongs to your family. And yet these assets have to go through the court system. But the worst part about it is that the court system is not fast. Y'all know that, right? Y'all know that it could take years sometimes before people go on trial. That's the same thing with probate. So your house can be locked up in probate 1 year, 2 years, 3 years, especially if there's a contest, right? Especially if there are people or creditors or other siblings, family members coming after what you left behind. That can take years. Your house is sitting in probate for years. No one owns it. It is tied up in the court system. But most importantly, or the worst part about it, like I mentioned earlier, is that foreclosure is definitely kind of on the radar, right? Now, let's say scenario number two, you and another person are on the deed, right? So as you know or may not know, there are two ways that you can hold title when it's two people, right? You can own title as tenancy in common, or you can hold title as joint tenants, right? Now, if you own title with someone and you're joint tenants, right? That means that your share automatically transfers to that other person. So if I'm hold title joint tenants, my share doesn't, and I pass away, my share doesn't go to my children. My share doesn't go to my parents. My share doesn't go to whomever. My share passes to the other owner, right? So this could certainly be a problem if you intended for your share to pass to your heirs, but instead it's passing to your sister because you bought the house with your sister. So you have to be very careful how you hold title with an individual if they're not your spouse, right? Now, what about tenants in common? So tenants in common means that the other owner keeps their share, but your share goes through probate. So if you're tenants in common and you own 50-50, So like you own 50, I've seen situations where two siblings buy a house together, two sisters buy a house together and there's a 50-50 split and they own it as tenants in common. That means that when I pass away, my 50% will go to my children and then my sister retains her 50%, right? Um, and what if the sister wants to sell the property because you've passed away? She doesn't want to have to deal with the mortgage all by herself. Well, she can't. She can't do anything because she owns it as tenants in common with you. And so she has to now wait for your 50% to go through probate, which can take 1 to 2 years. So imagine again, she's in a situation where she can't afford mortgage by herself. Your 50% is tied up in probate. What's going to happen? That house could again fall into foreclosure. Okay. So what about transfer on deed? You might be thinking, well, Shanice, New York has a transfer on deed statute. All I got to do is name my spouse or my mom as the beneficiary of the deed. I can just name her on the deed. Okay, but what happens if mom passes away? And then what happens when mom passes away or and then you pass away and you never changed it? You never updated mom to somebody else. Well, now that house has to go through probate because there's no attainable beneficiary. You had mom died, you never updated your deed, and then you died. So now that house is back in probate, right? So what's the solution to this? How can you avoid all of this? Well, there's really only one way. A will is not going to do it. Transfer on deed is not going to do it. A joint tenancy or tenancy in common might do it depending on who's the other owner, right? If it's a spouse, then maybe it's okay. But what if you own it with a parent? I know some situations where the mom can't qualify for a mortgage, so their daughter or their son is on title with them. So what happens in those situations, right? So the only way to avoid this, to make sure that that wealth doesn't disappear again by that second generation or that third generation, is to put it in a trust, right? So, but before we get to a trust though, what about a will? Shanice, I've heard that all I need is a will. What if I have a will? Isn't that enough? Well, look, a will doesn't do anything except give the judge instructions that he does not have to follow. Okay, that means that your assets are still going through probate. For me, I feel like dying with a will is as if you had died with nothing. The only thing it does is say, here, your honor, here's a paper with her wishes laid out on it. And the judge can say, oh, this is nice. I like that. Okay, but I don't agree with this, and that, right? And so the judge can then now override it. Remember the example I gave you with the father with the 7 children? The father left a daughter in charge, and what did he do? He overrode it, right? So a will is just money with no structure. No structure whatsoever. A will passes money, but a trust passes legacy and values. Okay, I want you to remember that. A will gives instructions, but a trust gives vision. A trust ensures your family inherits wisely and not wildly. Okay, so let's talk about a trust. What exactly is it? You guys hear this term all the time. People confused, people thinking that it's protecting their assets, people thinking that they don't got to pay child support, they thinking that they don't got to pay student loans, just put everything in a trust. Well, let's break it down. What exactly is a trust? A trust is nothing more than an arrangement that is set up through a legal document. So it is, I don't have my trust binder over here. My husband just cleaned up my desk area and moved my trust binder, but basically it's a legal contract, right? It's a legal document. And this document is a powerful document because it gives someone the power to make decision about another person's money or property that is held in that trust, okay? So very powerful document. And let's talk about who the parties to the trust are, right? So we know that a trust is a legal arrangement. It's a legal document. So who are the parties to the trust? So you have 3 parties to every single trust. Doesn't matter what type of trust is, you're always going to have these 3 people, the initial people at least, because there can be successors to these main persons, right? So you have a grantor, who's also known as a settlor. So if you see the word settlor here, that just is another fancy word for grantor. And the grantor is the person who makes the trust document. They're the ones who fund the trust, at least initially. They're the ones who contribute their assets to the trust. So for most of us, we're generally the grantors of our trust, right? We are the ones who are funding it with our assets. So we are called the settlor or the grantor. Now you have the trustee, okay? The trustee is the person who's making the decisions about the money or the property that is held in the trust, okay? A trustee is a fiduciary position, okay? It's a fiduciary duty, or title. They hold legal title. I don't want you out here thinking that, oh, I made somebody the trustee. That means that they own all of my assets. No, they hold a legal title, not equitable title. We're going to talk about who holds equitable title. A trustee only holds legal title, meaning that they're the ones who has control. They're the ones that have control over the assets. And you can be your own trustee. So for a specific type of trust, right? So if you have a living revocable trust, you are typically the grantor, the person who's creating the trust, and then you are also the trustee, the person who is controlling the trust, okay? And then when that person dies, when the trustee dies, you have something called a successor trustee. So it's the person who steps into the shoes of the trustee. So maybe if you made your mom the trustee of your estate, and let's say you passed away already, if mom dies, then there should have been someone else that you designated in your trust documents to step into mom's shoes. I usually recommend at least having like 2 to 3 successor trustees, because if everybody's falling out, we need to make sure that this trust can still we need to make sure that this trust can still continue, right? And some people will appoint a institution like a bank as a trustee because they're like, okay, I know a bank is never going to die. They're going to always be around. The Rockefellers have used JP Morgan Bank since the 1700s, the 1800s, right? So a bank is definitely more reliable than a person, but banks will charge you a fee to act in that role. Typically, it's either 1 to 2% of the the value of your estate for as long as they're managing your estate. And then we have the beneficiary. The beneficiary is just as it sounds. It's the person who benefits from the trust or receives the money or the property from the trust. And remember how I said a trustee holds legal title? A beneficiary has beneficial interest. They hold equitable title, right? This just means that they have the right to benefit from the trust, okay? So again, during your lifetime, depending on the type of trust you set, you can be all 3 roles. You can be the grantor, the person who creates the trust. You're the trustee, the person who controls the trust, and you're the beneficiary. You are benefiting from the trust while you are alive. And when you pass away, someone else steps in as successor trustee, and then now maybe your children become the beneficiaries of your trust. You've left your assets to them within the trust. All right. So then we have this is really important when you're thinking about who's going to be my trustee, because I sit down with people all the time and I'm like, okay, we gotta draft your trust documents. Okay, so who's going to be your successor trustee? Man, I ain't never really thought about that. I don't really trust my mom. I don't really trust my brother. This is something that you need to be thinking about, because a trustee is basically like giving somebody power of attorney, right? You're giving them authority to handle your assets while you are not here, and not even just in death, but in the event of incapacitation, right? So imagine you are on a ventilator or you're unconscious, right? You can't make the decisions. Your trustee can step in and start making financial decisions on your behalf, right? You can limit it, or you can have a power of attorney that kind of takes over. But there are times where a trustee will act on your behalf financially while you are incapacitated. So you need to make sure that you are choosing this person wisely. You are thinking about it, putting much thought into it. Some people choose their pastor. Some people choose even an attorney to represent them as to be the trustee, because they're like, I don't even want my family to even know what I got, right? So there are 4 functions of a trustee. I want you to remember, as the acronym is DICA, DICA. They have a distribution function, meaning that they have to ensure that all the beneficiaries are receiving their distributions. They have an investment function. Their job is to manage and grow your trust assets, and they can do this in conjunction if you have like a family office, which is something that is common in a Rockefeller or Dynasty type trust. A family office may consist of like a lawyer, a CPA, a financial advisor, a realtor, a lender, so they can manage and grow your trust assets in conjunction with your family office, right? They have a custodial function, and this is to make sure to safeguard your assets, your trust assets. And then they have administrative function, which is to handle the record keeping and compliance, because when you pass away, your trust, as long as it is alive, is going to have to get an EIN number and it's going to have to file tax returns, right? It's going to have to be compliant because it's a living entity. Okay, so it's very important when you're choosing your trustee. So that was the trustee functions. Let's talk about the trustee's duties. Remember, this is CLIP. So their functions is DICA. The clip is the trustee's duties. Okay, they have a duty not to commingle, because you'd be surprised. I know I had mentioned that you could have a law firm as a trustee, but sometimes there are lawyers out there that are shady and will go into the trust and take unreasonable fees and pay themselves unreasonably and commingle their assets with the trust assets. So you got to really think about this, guys. I don't know how else to overemphasize this, but it's really important because they have a duty, they have a fiduciary duty to keep trust assets separate from personal assets. And even while you are alive, you have a duty as a trustee to keep trust assets. Maybe you have personal assets that you're not retitling into the trust. So then you have a duty of loyalty, right? To act in the best interest of the beneficiaries. You have the duty of, when I say you, I'm talking about the trustee. The duty has the trustee has the duty of impartiality to treat all the beneficiaries equal, right? So, or fairly, I should say, because there may be allocations that are going to be different for each child. They have the duty to inform and account. So make sure that even when you're having meetings, I encourage you to have meetings, family meetings with your nucleus family, people who are going to benefit from your trust if you are not here, to let them know what their rights are as a beneficiary of their trust. You may say to your son, your 18-year-old son or your 19-year-old son or your 20-year-old daughter, hey, look, when I'm not here, this person is going to be the trustee of your trust, but know that they have the duty to inform and provide you with accounting. So if something is not right, if something is not sitting right with you, if you got questions, if you want to demand trust activity accounting, what is being paid out of this trust, how much the trustee is receiving as compensation, they have the right to do that. Remember, they hold equitable title. They have the right to demand accounting from whoever the trustee is, right? So, and then lastly, they have the duty of prudence. The trustee has the duty to manage assets wisely and responsibly, right? And that's why having a family office is so important, because yeah, you may make your mom the trustee of your trust, but mom may know nothing about trading. She don't know nothing about the SP 500. She don't know nothing about crypto. She don't know nothing about real estate investing. So even though she's trustee and managing and overseeing your trust, that she might work well or pair well with maybe your financial advisor, or your, a lender, or somebody who's well versed in that area. Maybe you have a mentor that can sit that can be a part of your family office to say, hey, look, mom is going to be trustee of my trust, but I'm going to put in my trust that she needs to consult with you guys quarterly to make sure that my assets are not depleting, right? That's not the point. The point is not for the assets to deplete. The point is for the assets to regenerate, right? Regeneration, right? For generational wealth, right? That is how you're going to create generational wealth, to make sure that your assets are going to continue to replicate and replicate and replicate at every generation. All right. So let's talk about the two types of trust, right? And when I say two types of trust, I'm really talking, because there are hundreds of trusts, but they fall into two categories. A trust is either going to be revocable or irrevocable. And this is where a lot of people get confused. They're like, well, I want asset protection, but you're creating a revocable trust, which is not what a revocable trust is going to do. So let me talk to you through the difference. Okay, I'm going to give a very practical example, one that you can never forget, the difference between a revocable and an irrevocable trust, okay? So I want you to think right now in your head, think of your trust as a car, okay? A car, just a vehicle, any car, whatever car, minivan, whatever, Audi, BMW, whatever, right? While you are alive, you are placing your luggage into that car, right? So you're about to go on a car ride. You are putting luggage into that car. Your luggage represents your assets, okay? And your car is going to represent your trust. So you're putting luggage in the car. And to analogize that with a trust, you're putting your assets into the trust, right? So because you put the luggage into the car, that makes you the grantor, okay, of the trust, right? And because you are a grantor, you transfer the luggage, you put the luggage in. But with the revocable trust, you are also the trustee, which means that you are the one with your hands on the steering wheel, right? You are the ones driving. You have the control of the car. You are driving the vehicle, okay? With the luggage in the back seat and you sitting in both seats. You're sitting in the driver's seat and you're sitting in the passenger seat as both the grantor and the trustee. So this means that because you are both grantor and trustee, here's the thing. You have the ability to steer the car. You have the ability to make turns. You have the ability to press the gas, press the brake, stop the car, car, turn the car around. You are in complete control of the luggage that is in that vehicle. You also have the ability to take luggage out of the car and put luggage in the car. You have the ability to ask people to put passengers invite passengers into the car. You have the ability to remove passengers out of the car. Those passengers represent your beneficiaries. So you can make those updates. As long as you're driving the car and you're the one putting the luggage in the car, you have all of that control, right? Now, because you have so much control, you are the ones with your hand on the steering wheel, you're in both the driver's seat and the passenger seat. What does this mean? That means that the car that you are driving, the doors are unlocked. And because the doors are unlocked, that means that a creditor can come up to that car, open the door, and remove your luggage from the car. So there is no asset protection with that type of trust because the doors are unlocked because you are driving the car. You are in complete control of that car. Okay. Now, the moment you die, someone else takes over as the driver of that car. That is called your successor trustee. But here's the thing. At the time of your death, whoever was in that vehicle when you died, so whatever passengers were in that vehicle when you died and whatever luggage was in that vehicle when you died cannot be changed, moved, or amended by that successor trustee. They have to follow the directions that you put in the GPS. Okay, so they have to continue that route, the instructions that you left behind, they have to continue that route until the trust terminates. But the advantage with the revocable trust, you may be thinking like, why would somebody want that type of trust? If a creditor can just come up, open the door and take my luggage out, why would someone want that? Well, because some people like to be in control. We don't like the idea of giving up control of our assets, especially when we work so hard for it, especially if you like are a first generation, homeowner. We don't like the idea of our trust being retitled to something else. So again, it's for control and it's also for ease of management. It makes it easier to do things. It makes it easier for you to sell your house or refinance your house. It makes it easier to just access your bank accounts. It's just an easier way of just living, right? Especially if you're going to retitle everything in the name of the trust because you're in so much control. And you can remove beneficiaries. So if you had a falling out with your mom, you had a falling out with your sibling, yep, I'm kicking you out of my trust. You can't do that with the irrevocable trust. It is very difficult to do that. But the advantage of the revocable trust is that instead of that car driving to the courthouse, right? That car is going to keep driving. It doesn't have to go to the courthouse. It bypasses the courthouse. So it never ends up in the court parking lot. That is the advantage with the living trust. But the disadvantage is that the doors are unlocked. And if you contrast that with a irrevocable trust, your hands are not even on the steering wheel. You may not even be in that car, depending on the type of irrevocable trust. You may not even be allowed to be a passenger in that vehicle. You can't be both a grantor, the person who puts the luggage in the car, and a beneficiary, a passenger in the car, right? But the benefit with this type of trust is that the doors are locked. I'm talking about locked solid. So if a creditor comes knocking, they come up to that vehicle, there is no way that they can open that door and take the luggage out. It is a solid asset protection tool. And it's really beneficial for people who have really high net worth, right? Lots of assets, because again, we're always going to be concerned about creditors trying to come and deplete our wealth. It's also a really great strategy for someone because you have high assets. The number one thing we're trying to avoid legally is taxes, right? Anything held in an irrevocable trust is not subject to estate taxes because you are not looked at that irrevocable trust is separate from you. It has a separate EIN number. It is a separate legal entity. So you are it's as if you went up to a stranger and gave them, say, here's everything that I own. Here, you take control of it. That's why there is asset protection because you do not own it. You are not in control. You do not own that trust. All of your assets are sitting in that trust for the benefit of other people, like your spouse or your children or your parents, right? So it is being held in this vehicle for the benefit of someone else. That is why it's an asset protection strategy. It's a tax strategy. A lot of wealthy people tie their assets up into different types of irrevocable trust. There may be a life insurance trust, an irrevocable life insurance trust. You might have a domestic asset protection trust. You may have a dynasty Rockefeller trust. So those are all different types of irrevocable trust. Okay, so let us go to, I'm going to give you an example. Let's go back to the revocable trust, the one where you are both driving the car, you are a passenger in the car, and you are the person who puts the luggage in the car. This is what the introductory paragraph looks like of a revocable trust agreement. Okay. So this is obviously, I've removed names for the purposes of, attorney-client privilege. But basically, John Smith revocable trust agreement, and your trust doesn't have to have the word trust in it. You can name it whatever you want. You can call it 4231 Dynasty, 4321 Estates, John Smith Estates. And you don't even have to put your name. You can call it Greenfields or Green Acres Dynasty or Green Acres Estate. So you don't have to use the word trust, because the body of the document will let us know whether it's a revocable or irrevocable trust. Okay. So basically, like I said, right, I said it's a contract. A lot of you, probably every single one of you have seen a contract before, and it looks just like this, right? This trust agreement is made and entered into this day by and between John Smith and John Smith. That means John Smith is the settlor, which is the grantor, and he's the trustee. I know it seems weird that you're entering into a contract with yourself, but that's what it is. So you are entering into contract, and that could be anybody. Maybe Jane Smith. Maybe Jane is the trustee. So John Smith is entering into contract with Jane Smith, and it says the trustee agrees to hold the property transferred by gift, bequest, or other means as an estate, as a trust estate for the following uses and purposes. And so your trust document can lay out, why is this trust created? What is your intention behind creating this trust? Is it for asset protection? Is it for generational wealth? Is it for wealth preservation? Is it for avoiding estate taxes purposes? So you can lay out the purpose of this trust. Maybe it's for your grandchildren that aren't yet born. So you can create whatever purpose it is that you want. And this is how title will be held. Okay. So when you are retitling your assets, when you are funding your assets, this is how it should look. Again, this is if you want to be trustee of your trust. Again, you can appoint a law firm, you can appoint an entity, you can appoint your pastor. But let's say, for example, you are the trustee. So it's going to say John Smith and trustee of the 567 Lakewood Estate. Remember that, you see how that didn't use the word trust, right? So some people don't like using the word trust. They don't want people knowing that it's a trust if they, retitle their assets. So trustee of the Lakewood Estate. And then you have the date, okay? Because your trust has to get notarized in order for it to be, in most states, it has to be notarized and witnessed in order for it to be enforceable and valid. So what was the date that it went into effect? So you can do John Smith of Lakewood Estate, you can do John Smith of Lakewood Living Trust, or you can do John Smith of Lakewood Dynasty. So you can literally, guys, it's completely customizable. It's not cookie cutter. Like there's no one size fit all. You can literally customize this to however you want it to be. So and then for my parents on the call, this is something that I did for, I'm gonna see if I can zoom in. This is something that, I did for a client recently. So basically, she's a single mom. She has 2 kids, and she wanted to, her twins are, I think they're 3 years old or 4 years old. So obviously, if she dies, right? She's not married. She doesn't have a boyfriend or anything like that. So if she passes away, she wanted to make sure that her assets were going to be held in trust for her children. So this is what we called a sub trust. So it's a trust that is created within your trust document that is technically asleep until something happens to you. Once something happens to you, that trust becomes activated. It becomes alive. It's a sub trust. Your assets now flow into the sub trust, and you can have as many sub trusts as you want. She happened to have 2 because she has 2 boys. Well, she has a boy and a girl. And so we've created a trust for each of for her daughter and for her son. And this is how she broke it down, which I really liked this way that, when we had our strategy call, what she wanted to accomplish. But basically, she broke it down by their ages. So she basically said, okay, I could die tomorrow, right? They're 3 years old. So let's start about what could happen tomorrow. Let's not think about, okay, I want to leave this amount to them when they're 18. But what about now? If something happened to me now, how do I want my trustee to deal with my assets when it comes to my children? So we broke it down into different sections. So we have a section where it talks about distributions from age 3 to 5. So if you look here, she says, from ages 3 to 5, the trustee shall utilize the subtrust funds to pay for, and she listed everything out. I want my trust funds to pay for daycare. I want them to pay for clothing. I wanted to pay for life insurance premiums because she has life insurance policies on them. She wanted them to pay for medical, dental, and vision, and any other payments that was going to benefit her child. So like extracurricular activities. Basically, what she wanted this trustee to do is maintain the same amount of comfort and accessibility and privilege that she's giving them now. She doesn't want anything in their life to change if she's no longer here. She still wants them to be able to live the life that they're living now if she were gone. So then she goes from 3 to 5. Okay, from 3 to 5, I know that they're going to need daycare. I know they're going to need essentials as a toddler, as a basically a baby, as a child. But now let's talk about what happens when they mature to 6 to 18. Now they're a little older. They're probably going to be attending public school. They don't need childcare or daycare costs to be covered. So now she's focusing on things like field trips. She's focusing on things like educational supplies, laptops, school materials, clothing, maybe even cell phone service, which she put in here should start at the age of 8, right? She's still focusing on life insurance premiums. She's focusing on medical, dental, and vision insurance, right, for her children. And there was other categories in this list that she included, but for the purposes of time, I didn't put that in there. Now, when they turn 18, when they become a majority, let's see here. Let me make sure I'm swiping. Hold on, y'all. My computer is okay. So from ages 18 to 24, now she's expecting, okay, by 18, they're gonna be in college, right? So and they're gonna be a young adult. So what are the things that we should be thinking about from ages 18 to 24? Well, she's thinking about room and board, right? Like if they go to college, or maybe they don't want to go to college, but they want to do like have a apartment. She's thinking about the rent for suitable housing. She's thinking about utilities, right? Electricity, internet, water. She's thinking about food and clothing and transportation, specifically getting a car, cell phone, and she specifically put in here, as far as vehicles, that they have to basically prove to the trustee that they are capable and responsible of handling a vehicle. So she even has those type of disclaimers in here about at what point they can get a car, and prove to the trustee that they are capable of operating one. And then so after 24, instead of again giving it to them outright, right? Because at 24, she could have technically just said, okay, you get all the money at 24. You're adult, you're responsible. But no, she went a little bit further and said, this is what I'm going to do when they turn 24 up until, okay, my screen, come on. She staggered the distributions from age 25 to 37. So at 25, they're going to get 20%. And she says that this 20% is going to be intended for a down payment of a primary residence, or even for acquisition of real estate if they want to buy an investment property. At age 28, they get 20%. At age 31, they get 20%. At age 34, they get 20%. So 20% is being paid out from age 25 to age 37. And at age 37, they are getting the final payout. So the trust will terminate when her children are 37, because at that point, she feels like they had enough, oversight by a trustee. They're now capable and responsible of handling their own funds and, starting to invest in their own way. But this clause right here is really important. This is it's called a spendthrift provision, okay? This provision is what is going to protect your children's inheritance from their creditors and from divorce, right? She was very concerned that, like, okay, what if my son marries somebody that I don't like, right? I don't know who he's going to marry. And what if they try to go after what he has? Well, we put in the spendthrift provision because what this does, it basically says that no, if you look at the second paragraph, no creditor, spouse, former spouse, judgment creditor, trustee in bankruptcy, governmental agency shall have any right to attach, garnish, levy, seize, or reach any interest of this subtrust, right? So it is essentially an asset protection clause, a spendthrift provision, and not every attorney that will put this provision in there. They will charge you extra for putting this asset protection provision in there because it's so powerful. It is essentially protecting your children from their creditors or from future divorces or spouses, right? All right. And then the second part of this, so we have that spendthrift provision in there for her. And then we also created, and I know I'm running up on time. I think I'm past the 45 minutes, but that she really, we talked about this. This was something that was really important to her based on some of the videos that I was posting on my Instagram. And it's for legacy planning. So basically, the clause that we included in here, we basically said when her son or her daughter has a child, there's a requirement in her trust for them to create a trust for their child. So now, even at 3 years old, she's already preparing for her grandchildren. This trust will already prepare for her grandchildren. So when her son or her daughter has a child, they have to create a trust for that child. And if you look closely on I don't know if it's in this paragraph, but basically it says that the grandchild um fund or trust gets funded with a certain percentage. All right, I got 10 minutes. Gets funded with a certain percentage of her trust assets. So for you, it could be 5%, 10%, 15%, whatever it is. The point is that you can prepare for your grandchildren, even your great grandchildren, by including a subtrust like this and provisions like this. All right, let me kind of run through this. So let's just focus real quickly on irrevocable trust. I know we talked about the car example, but let me tell you the three different main ones or popular ones. So you have like your typical irrevocable trust, right? There's a grantor, the person who creates the trust. You have a trustee, which is a third party. But here's the thing with the irrevocable trust. You are not the beneficiary. That is very crucial. You could possibly serve as both grantor and trustee. I don't recommend it. I say if you're going to be the grantor of an irrevocable trust, I don't also want you serving as a trustee, because that's a way to pierce the trust's veil. And I don't want the court to be like, well, he did or she did retain these powers. Like we will draft it in a crafty way that still kind of, even though it's an irrevocable trust, we're still going to kind of give you some powers. We're not going to leave you completely powerless. I don't really like some older lawyers would be like, absolutely not. We're not giving them any powers. This is an irrevocable trust. There are crafty ways. There are unique ways that we can make it work. But I'm not going to make you the beneficiary of a standard irrevocable trust, because that's gonna avoid your irrevocability, right? It's gonna be hard to prove that this is an irrevocable trust while you're still benefiting from the trust. And so this is really going to be for just straight asset protection purposes, straight removing assets from my estate so that I'm not taxed and getting complete asset protection. Now, there's something called a domestic asset protection trust. So you remember that the general irrevocable trust where you can't be beneficiary of the trust and also the grantor? Well, in 20 states, they have a statute, a domestic asset protection statute. It's called a DAPT trust, DAPT. And in almost 20 states, you can have the irrevocability benefit, right? You can have the locked door, the locked car, and be a passenger, be a beneficiary of that type of trust. So you can be the grantor, the person who puts the luggage in, and also be the beneficiary of that trust. This is the key difference between your typical irrevocable trust. So if you are looking for asset protection, but you still want to be able to benefit from that trust, and you still want to have that locked door car, then if you live in one of these 20 states, like there's Nevada, there's Rhode Island, there are many different types of, again, there's over 20 states. I can't remember them off the top of my head. They will allow you to be both the grantor and the beneficiary. I wish I live in Massachusetts. Rhode Island is literally a hop, skip, and jump away. Man, if I lived in Rhode Island, I'd take advantage of this domestic asset protection trust because I'm getting my asset protection that I really want. And I can be a beneficiary of my trust while I'm alive. Okay. So that is the primary difference between like your standard irrevocable trust and a domestic asset protection trust. Now, there's something called a dynasty trust, a Rockefeller Trust. This trust is specifically going to be used for long-term wealth preservation. Okay, over multiple generations. So you want your trust to never end, because a trust ends. It has a termination. It's something called the rule against perpetuities, RAP, okay? After a certain amount of years, the trust has to terminate, okay? And usually a trust term is anywhere between like a 90 to 100 years. But for some people like the Rockefellers, that trust was created, gosh, I don't know, 1700s, 1800s, whatever. And it is still going on today because it is a dynasty trust. It's a trust that technically does not end. It continues to go on and on for generations after generations. In fact, there are some states that say it doesn't have to end. It never ends. Some states will allow it to go up to 1,000 years. So just depending on the state, or how long you want the trust to go on for, we can look into the state that will allow you to be able to do that. But the key is that you have to have some nexus to that state. And you don't have to live there to create a dynasty trust, the one that never ends, but you have to have like a trustee who is in that state. So a lot of, because, Delaware, South Dakota, especially being like the #1 dynasty trust state, they have trust companies that are literally set up for this specific reason. They know people are going to flock to South Dakota to set up this type of trust because their trust, they have one of the most, the highest asset protection type of trust. So people are going to flock to their state. So they have these companies that specifically serve this purpose. So if you are interested in kind of a dynasty legacy Rockefeller Trust, I would highly recommend South Dakota as kind of one of the top states to be able to do this, but you will need to get a trustee in that state. Okay. So lastly, let's talk about two points. These are my last slides. What not to do and then what to do. Okay, these are 3 things that you should not do. Okay, do not name your minor children as beneficiaries of your life insurance policies. Why? Because we talked about that outright distribution, that you're setting yourself up for the 3rd generational curse. Your 18-year-old cannot handle an outright distribution of $1 million. That's not reality. That's not realistic with no parameters. It's like driving on a highway with no guardrails, or no lanes. Number 2, do not transfer your home to your children during your lifetime. Capital gains tax. Your child will have to pay capital gains tax when they go to sell that house, right? So no stepped up basis. So do not do this. Do not leave your assets outright to beneficiaries with special needs. So if you have a child that is receiving government benefits and you leave their assets in a will or outright distribution, you are going to disqualify them from receiving government benefits. So we create something called a special needs trust. It's a type of irrevocable trust that is specifically designed to hold the assets that you are leaving a child with special needs so that they can still qualify for Medicaid or government assistance. Okay. Now let's talk about what to do, right? So that's what you're not going to do. Let's talk about, okay, Shanice, what should I be doing? Well, the first thing you need to do is figure out what type of trust you want, right? Are you looking for asset protection? Are you looking for control? Are you looking to minimize your tax liability? Are you looking for something that's going to last for generations? We just have to figure out what trust type is best for you. Then you have to choose the parties. Remember the 3 parties? You have a grantor, a trustee, and a beneficiary. Who is that going to be, right? People that you trust. Do you need a family office? Do you need to set up a family office of trusted people that can sit, a family office and even a board of trustees? So you can have your main trustee, but then you can have a board of trustees so that not one person is making the decision, but you kind of have this group of people who are making a decision for you rather than one person dictating everything. And then you can even have something called a trust protector. A trust protector is basically kind of in the background until there becomes an issue with the board of trustees where they can't agree or the trustees trying to do something that is contrary to your wishes. You can have somebody come in as a trust protector to say, this is not what Shanice would have wanted, and can essentially veto or override that decision that's contrary to your wishes in your trust document. So you're going to choose your parties, determine if you want a board, determine if you want a family office, determine if you want a trust protector. And then you're going to you're going to draft the trust agreement, not you. You need to have a professional do it, and specifically an attorney, specifically me, if you want to work with me, right? There are a lot of people on Instagram that are labeling themselves as trust advisors and literally putting out foolishness, right? And creating a whole bunch of confusion in this space about what protections you get, what protections you don't get. If you lock up all of your assets, there's this one, I ain't gonna say no names, but you lock up, she's encouraging people to put everything into an irrevocable trust. You locking up all your assets in an irrevocable trust. How are you going to tap if there's an emergency? How are you going to tap into your brokerage account in an irrevocable trust? If you need to sell that house, if you need to buy more assets, if you need to remove a beneficiary, you got everything tied up into an irrevocable trust, you are creating a disaster for yourself, complete disaster. And especially when you think that you are protected and you're not protected. I mean, I'm really concerned. I'm really concerned that the trusts that are being created by non-experts, non-attorneys, when that person passes away that had them create a trust for them, there's going to be a lot of court cases that are going to be coming out in the next 20, 30 years of people who used non-attorneys to create their trust for them, and then their family ended up with nothing because they didn't know what they were doing, right? So that's beside the point. So you're going to draft a trust agreement, then you're going to open up a trust account, and then you're going to fund the trust. Okay. So my last two slides is what does a trust account look like? So when we talk about trust fund, this is what I'm referring to. You literally can go to Schwab. I have my trust account is opened with Schwab, and I just took a screenshot. I went to their website, typed in trust account, Schwab. There are credit unions that allow you to open up a trust account, or you could just open up like a brokerage trust account, right? And so this is what Schwab's page looks like. It says, let's open up your revocable living trust. And it's even telling you what the benefits of doing this is, right? So you can use Schwab, you can use Fidelity, you can even call your bank to see if they have that option. So you can so you have a trust account that you open up with Schwab, and then you need to start funding your trust. If you do not fund, this is probably, if you take nothing away from what I said today, please, 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 please fund your trust. If you don't fund your trust, your trust is nothing but a piece of paper. There are two ways to fund your trust: transferring title, so retitling all of your assets, or naming your trust as a beneficiary. Those are two options. And whether you should do one or the other is circumstantial. It's going to really depend on your situation, on your circumstance. I'm never going to tell people, oh, you should only name beneficiary. For me, I personally retitled everything. There are certain things you can't retitle. You can't retitle retirement accounts, right? Your 401k, your IRA, your pension. Those are things you can't retitle. You're going to create a taxable event. In fact, you can't retitle it. But you can name your trust as a beneficiary. So your option is going to depend on what assets you are putting into the trust. So retitling might make more sense for like a house, right? Creating a new deed, and retitling is going to make sense for bank accounts. But for life insurance policies, that's going to really be more naming the trust as a beneficiary, and even retirement accounts naming the trust as beneficiary. The whole point is that when you pass away, your life insurance proceeds, your SEP IRA, your 401k, your IRA, your brokerage accounts, all of that is being paid into this trust fund, right? That trust account that you created or you opened while you were alive. So now all of that money is pooled into this one account. So now your trustee has direct access to that money. No foreclosure over here, no default on loans over here, because everything was created while you were alive and there was no confusion. So, my last slide looks like this, is you can call your bank. Come on. You can call your bank and have them do this. If my slide would go. This is a certificate of trust. This is basically a conversion, right? So I have Capital One, if you have an account right now, like a savings account, you can convert, depending on your bank. Not every bank allows you to do this. You can convert your existing bank account to a trust account. Okay, so this is what Capital One's a form looks like. It's called a conversion form, and it basically is saying you have an account already and you want to convert it to a trust account. So you're converting your savings account to a trust account, but you need to have a trust created first before you try to do this. You can't open up a trust account without a trust, because they're going to ask for a copy of your certificate of trust. So you never give a full copy of your trust. You're only going to give your certificate of trust. And that is about 4 pages in comparison to your living trust, which is over 50, 60 pages. Okay, I'm done that's all I got. I could go on, but I know time is against us. So I'm gonna take questions now, right, Matt?
Man, this was straight fire. First of all, before we even get to the questions right now, I need everybody to throw some gems in the chat if you got like some high level education tonight, man. This was absolutely a masterclass in an hour. like like when I tell you that Shanice is the GOAT, she is the GOAT, ladies and gentlemen. You guys need to tap in, first of all, because we're not going to be able to answer everybody's questions tonight. How can they contact you, book a consultation? Like, because I know everybody in here, we got over 50 people on YouTube, over 100 of the mentees here on the Zoom right now. How do we get in contact with you before we get into questions, please?
Yeah, I'm gonna put my website link into the chat. You can go straight to that website, book a call with me, just choose which call is applicable to you. If you're looking for, asset protection advice, if you're looking for estate planning advice, if you're looking for business advice, then I offer all those type of different calls. So you're just gonna choose a call which is applicable to your situation. So let me put that in the chat right now.
So also say it so the folks on
Oh,
you.
yeah. So my website is marksetgolaw.com. Marksetgolaw.com. You can look at my website and see all the services that we offer. I just put my contact us link, my direct link right into the chat for you. But my law firm is marksetgolaw.com. It's also in my bio on my Instagram page if you're having difficulty typing it into the URL box or clicking the link.
Okay. What's your Instagram?
Oh, my Instagram is at the real REEL lawyer.
Hmm.
I just put that in the chat too. Thank you, Joanne.
All right. So mentees, I need everybody that's a part of the inner circle. Go to the website, schedule your calls. We're not just about buying real estate and making money and everything like that. The reason why all of us are doing this is to build something for our future, to break generational curses, right? That's why we all are here tonight. We're learning. This is why you guys have invested the type of money you have invested to be a part of this beautiful community that we have. You have to break generational curses. And how we do it is doing everything that Shanice has taught us here tonight in a short period of time. Now, mind you, when we had the inner circle in person mastermind in New York, she went for 6 hours straight. Oh, it was incredible. It was incredible. Yo, that video too, I got the whole video too. I might give this to my Diamond and Elite members because that 6 hours is just pure gold. I'm holding on to that like oh man, but that was a beautiful thing. All right, so let's take some questions. I wanna it's 9:21 right now. I don't want to just take some questions. So I want people to raise their hand and I want you to be camera ready. I'm only taking questions from the people who are camera ready with their cameras on. If you don't have your camera on, I'm not taking your question. Um, okay, we got a winner. Odara, I'm gonna ask you to unmute yourself. And
Hi, good evening.
how are you?
Good, good. Thank you so much for providing this and for the information you gave. Just wanted to touch base. Are you licensed in all 50 states or are you only able to write in certain states for state drafting?
Wait, hold on, Shanice. Hold on. I gotta unmute you. Hold on. So Shanice, just don't unmute yourself no more. Don't mute yourself no more.
Oh, don't mute. Oh, because then I gotta keep getting
Yeah,
unmute.
don't mute
Okay,
yourself.
okay. So we can help in New York, Georgia, and Massachusetts. And if you are not in one state, I can connect you my network, my colleagues I work directly closely with to draft that trust. So may not be specifically able to draft the trust in like let's say North Carolina, but then I'll connect with my colleague and it's not like you get double charged. We do it together essentially.
Unmute yourself.
I don't think she can. Oh, there we go.
Thank you. No, thank you so much.
You're welcome.
Good question. Good question. All right, so when you guys come on, don't unmute yourself. When you come on, don't mute yourself again. Unmute yourself when I tell you to unmute yourself, but don't mute yourself again because the way I have my control set up that you can't unmute yourself. I do that purposely. So that way you guys can't some of y'all be cooking, yelling at your kids, like, come on, bro. All right, we need more questions. You need to have your camera on in order to get on this stage and get your questions asked and answered, right? Um, YouTube is asking me to put her info in the description of this video. You guys better take the information because this video ain't gonna live on YouTube. Just so you know. Okay. Pamela, I just saw you hand up, but you didn't raise it down. So Jay, I'm coming to you. Unmute yourself, Jay. We can't hear you, Jay. Jay, we can't hear you. You're unmuted, but we can't hear you.
Is it better?
Much better. Now we hear you.
All right. Yeah. So currently, I have my my fiance and our kids as my my beneficiary for my pension and my 401k. How long would it take to transfer that to a trust?
So every financial institution is different. You basically will go, you can, sometimes they have online portals where you can just go in and make the request, and they're going to ask for a copy of your certificate of trust. Sometimes they process it within a day or two. Sometimes if they have more questions, it might take a little longer, maybe like a week or so, but it shouldn't take longer than 5 to 7 business days. But that's just an average depending on the financial institution. But you can either call them to do the change, or you can do it online if you have an online portal.
What if you don't have one? You just want to create one?
You don't have what?
The trust. So you want to transfer?
Oh, how long
Yeah.
to create the trust?
Yeah.
Oh, I'm so sorry.
Okay.
So typically, if you have all, like you have all the information, like you know who your beneficiary is going to be, you know who your trust is going to be. There's no questions, like you know what assets are going to go in there. The drafting process takes anywhere between 1 to 3 weeks, just depending on the complexity of it. Like if there are multiple, like if it's a joint trust, for example, that's going to take longer than a single person, right? Trust. So if you and your fiance are going to do a joint trust together, and then there are multiple sub trusts, obviously that's going to take a little bit longer than if it was just you by yourself and you're doing one sub trust. So just going to depend on the complexity of it, but no more than 3 weeks.
Okay. Thank you so much. Appreciate it.
You're
Good
welcome.
questions. Any more questions before we let you off?
Oh,
Damn, Jay, you went
Out.
so fast. He was out. All right. So let me get rid of Jay, remove the pen. Let's go to Pamela. Pamela, unmute yourself.
Hi.
Hey, what's up, Pam?
Hey, thank you for taking my response. So what if you have money and you want to leave a trust, but you don't have family, you don't have children, and you don't want to leave it to your family?
That's a really great question. So a beneficiary doesn't have to be a person. It could be an institution. So I've had people who've left their assets to like their church, or to a charity. So if you don't want to leave it to specific people, or to anyone, you don't like anybody in your family, you can leave it to an institution or to a charitable organization, to again, like a church. Worst case scenario, like if you designate nobody or everybody passes away by that time, then it will essentially go to the state. So I'd rather you donate it to like a 501c3 or like a cause organization, someone, before it ends up going to the state. So that would be my recommendation, is certainly consider like a church or a charitable organization.
Okay, thank you so much.
Great question. Great questions. I'm loving these questions so far. All right, so let's keep the party going. Let's go to Shaq. Shaq, unmute yourself, please. There you go.
Hey, thank you so much for all the information that you've provided, Shanice. Yes, so my question is, when do you consider starting your trust? Currently, I'm a family person, single, just starting my business. When it would be the right time, or my checkoff list to say, okay, I'm ready to go ahead and start my trust.
Do you have children?
No,
Okay, are you in a like, are you married?
no.
Single man. So, and you do you have what, like, assets? Do you have it when we look through that list? Do you have probatable assets? That's something that would go through probate. Like, do you own a home or investment properties?
Yes.
Oh, then you need a trust. You need a trust, because if you wait, right, and God forbid something to happen to you tomorrow, your house is going to go through that process that we talked about. It's going to go straight there. So without the trust, then that's the only option for your house, is it's going to go through trust. There's no other option. So when you talk about for you, I say to people, do you have children? If you have children, you need a trust. Do you own real estate? You need a trust. So in your situation, you may not have children, but you own a probatable asset that otherwise would have to go through the court system. So why put your family through that when you can just create a trust and avoid all of that, avoid losing your house, avoid your bank account being frozen, and put it into that vehicle?
Well, just to follow up on something you mentioned, suppose you have assets in other countries. Does it work for that as well?
Yeah,
Or
are you from
no?
Jamaica?
Yes, I know.
Okay. Um, I'm Jamaican too.
Awesome.
You gonna
So
talk now? What we got? Well, on.
So if you have assets in other countries, unfortunately, your trust here doesn't have jurisdiction over there. So you should absolutely consider setting up a trust in the country or countries where you have assets. So I own property in Jamaica. So I would need a separate trust for that specific purpose. My trust here doesn't have jurisdiction over that.
Okay. Thank you so much. I appreciate you.
No problem.
Great questions. Great questions. Let's keep the party going. I'm loving these questions. All right, everybody, let me just take a quick TV commercial break to encourage everyone that's here on YouTube and also here in the circle. You need to, I put the link in the comments for marksetgolaw.com. Okay, marksetgolaw.com. You guys on YouTube are in the comments asking me for Shanice's information. I put the link in YouTube. I'm encouraging everyone who can hear my voice right now. Please, 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 please get your shit together. That's it. That's my TED talk. Okay, let's get back to it. Ty, I'm coming to Ty. She's a diamond member. She's a diamond elite. So Ty, where are
Hi,
you?
Shanice. How are you?
Good.
Thank you so much. So I'm in the process of establishing a trust, so I just paused. And I want to know with the consultation, I think it's called the trust that you mentioned this evening.
Children?
Yeah, I don't have children. No.
Okay. Or it doesn't have to be for a child. It could be for like a niece or a nephew.
Right, exactly. So where do I move forward with continuing to establish that trust, or do I pause and have the consultation with either you or someone from your team? What does that look like? What would you recommend?
So how far are you into the process? Of course, girl, I'm gonna tell you to come over to me, but how far are you into the process?
It's really weird. They had us go online and to fill out some information. It's a mastermind that I'm a part of.
Like it, Ty.
I'm sorry.
I don't like it.
I don't like it either. Right, exactly.
I don't like it, Ty.
Matt, don't get me started, please. Matt,
I
Matt,
don't like it.
Matt, I know. Bear with me. I'm sorry, Shanice.
Okay. So
Regularly.
it doesn't sound like it sounds like you should probably stop because like if it's something that you're not speaking to a direct attorney with, right? Like you're
Right.
not like they don't know your needs, like you're not sitting down with them and saying like this is what I want to create, this is what I want to do. What are your suggestions based on your expertise? What do you think I should do based on how much assets I have? Because we got to consider everything, right? It's a whole picture. We got to look at you holistically and then say, you know what, Ty, you got too much money sitting over here. Maybe we need to think, maybe you're in a state, for example, Massachusetts, our estate taxes is $2 million. So if my client has a $2 million life insurance policy and then they're sitting on $5 million real estate equity, they're going to pay a lot of estate taxes. So I need to start thinking about multiple trust structures based on their asset portfolio, right? So we don't want to just, again, not everything should go in one bucket for everybody. So I look at you holistically and determine a plan for you. And like you said, like you don't have to have children to do the subtrust, but if you have a minor or like a niece or a nephew that's a minor that you want to leave your assets to, it's the same theory applies. You don't want to leave it to them outright because they're a child, right? So as far as your question is concerned, I would pause and have a consultation with me so that we can figure out the best strategy for you. And then based on that call, then we can draft a custom plan for you. And you would be speaking directly with me, by the way.
That's perfect. I was scheduling my appointment with you, but I just wanted to pause to get your counsel on this call. Thank you.
And that's why I said I didn't like what you was going with that, Ty, because if someone's telling you to, and I don't care about nobody's masterminds and nobody's groups and none of that, right? This to me is too important to say fill out a form.
I agree.
Like fill out a form. Like what? Like we need to speak to somebody and it has to be from a holistic point of view. Everybody needs it different. That form doesn't have your needs or what your needs are. Like it's just, I don't like that shit. So
Right. That's why I paused because I would have several beneficiaries. They're all different ages. And when I heard you present tonight, I was like, wait, let me pause because I'm going to have different needs for different beneficiaries. Okay, perfect. Thank you.
So this is what I want to do too. I know you're gonna book your consultation and everything like that, Ty, but Shanice, Ty is a diamond member of mine. She's great people. I want to kind of connect you guys directly too, just so you guys know each other, right? And it just don't look like it's just another person on the calendar. My diamond people, I treat them like they're super, super, super VIP in my world.
I got you, Ty.
I
Thank
want
you, Matt. Thank you, Shanice.
Thank you guys. I
Thank
appreciate
you.
it. Thank you, Ty. All right. That was good. All right. Jose, I'm coming to you.
There you go. Put the thing.
Jose,
Yeah, you hear me? You hear me, Matt?
loud and clear, bro.
All right, my wife is gonna ask the question. We in a truck right now. We truck drivers, so we over here in Ohio picking up a load going to Pennsylvania.
All right, let's do it, bro. Be safe out there.
Yep.
So my question was, can you continuously add to the trust once it's set up? And if so, how does it work?
And you should be continually adding to the trust. A trust is not a one-time stop funding situation. The plan is that you're going to continue to get more assets, right? So you will continue to add to the trust, and anything that like life events, like a child or you get another house, essentially you come back to me like, hey, Shanice, I need to add this to the trust. Because if you don't add that asset to the trust, and that's a probatable asset, it's going to have to go through probate. So like I've had situations where a client has created a trust and then they never came back and say, hey, look, I bought another investment property. Now that investment property had to go through probate, even though they had a trust. So you essentially would reach back out to me, letting me know that something has changed in your financial situation or even your personal situation, again, like having another child. And then we would look it over to make sure that the trust is still suitable. It's still fit for you. And then we can easily amend it. It's not something that you don't have to amend the entire document. We're essentially adding that asset to the schedule of assets that are already a part of the trust. So we don't necessarily need to change the substance if you're just getting another asset.
So you're not in the state you mentioned, we're not in the state, we're in the state of Pennsylvania. So you said you have a network of
I do.
people.
And
So
someone
would
just
we reach out to you via email first and then you
Yes.
would set that up?
Absolutely. Send me an email and then I will do the connection and like I said, I'll work with an attorney in Pennsylvania, but a woman in my head just came to mind in Pennsylvania. I have my connection in Pennsylvania. So yep, just email me.
Did you put the email in the chat already? Your email?
Actually, I'll email it to you directly. Okay, gotcha.
Okay.
Great questions.
Thank you.
You're welcome.
Drive safe out there.
Hey, babe, tell Matt. Just tell Matt that we was listening. He can hear me.
Yeah, I hear you.
Just tell Matt. Oh, Matt, I was listening to your live last night, and me and my wife is one of the people that messed up and got married before we put the carriage before the horse.
Yeah, it happens, man. It definitely happened. I'm glad you guys was tapped in. That was Tuesday night.
Around. Yeah, we're trying to figure out a workaround, but we definitely gonna make some things happen and get with you.
Man, I would love to help you guys grow.
Thank you so much.
No problem, guys. Have a good one. Be safe out there. Shout out to my people, man. They outside working and grinding and tapping in. I love that. All right, let's go to Angelique. Angelique, unmute yourself.
Thanks, Matt. Good evening, Shanice. Thank you so much for sharing this good information. I'm a realtor in Detroit, and I often will see people transfer their properties from their personal names to LLC on the same day of closing or right at the closing table. So my question is, can you transfer something into a trust immediately upon closing on a property? And the second part of that question is, what happens if you pass away and you still have an outstanding mortgage on a property? Is that property automatically sold, or do you automatically have to sell it in order to have the proceeds go into the trust? Or can it remain in a mortgage as long as there are other means within the trust to pay the property off?
Really great question. So let's start with your first one, which was people closing in an LLC, like same day of closing. Let's look at that scenario, right? If you purchased
Yes.
property in an LLC, whether you transferred it the day of closing or you did it afterwards, that LLC owns property, so it's a property holding LLC, you will assign the LLC interest over to the trust. So you will do
Okay.
interest, so you don't have to retitle that investment property from the LLC to the trust. You're just going to transfer your membership interest to make the trust the owner of the LLC. Does that make sense so far? Okay.
Yes.
Now, in fact, you can actually buy a property in a trust. So you can actually buy a property in a trust. Yeah. And I think, Matt, we were supposed to do something about that, but talk about that. But anyway, yeah, so you can purchase property in a trust and have the trust on title. But you can do the same if you don't do that right off out the gate. You can do the same transfer, is transferring the property that you buy, deeding it directly to the trust. And most people do that with a personal residence as opposed to investment property. If it's an investment property, we typically will put it in the LLC and then assign the LLC over to the trust. If it's a personal residence, we don't do the LLC, obviously, because it's not a business. We'll just retitle it directly to the trust. Does that make
Okay. Yes, it does.
and that will not trigger the due on sale clause. You will be permitted to do that, to transfer the property directly into a living revocable trust. Regarding your second question, which was
if someone passes away,
what happens to
and the mortgage has not been paid off, is it automatically going to trigger a sale, or is it the trustee can continue to make payments as long as there are sufficient assets?
That's exactly right. The trustee, you can direct what you want the trustee to do. Like, for example, that example that I gave in the document with that client, she wanted all her assets to be sold. She wanted all her real estate to be sold. She didn't want to keep any of the real estate. So she wanted to liquidate all of her properties. So her direction to the trustee was, upon my death, or if I'm incapacitated for more than 6 months, I want you to sell all of my property, and all of the proceeds for the property would go into my trust fund, and then it would be distributed to my children according to the staggered distributions that we went over. So you have the option. You can have them sell the property and then get the equity and then distribute that to your beneficiaries. Or you can say, I don't want this property to ever be sold. I want this property to stay in my bloodline, stay in my family, and continue to pass on. Especially people do that with land. They might put a land in. That's right. So if those are your wishes, you can direct the trustee. This property should remain in the family and should never be sold, so long as the mortgage payments continue to be paid out. And you can even say, maybe if you have life insurance, maybe you say, take my life insurance proceeds, pay off all my debt, pay off the house, so that my beneficiaries are now inheriting, at least, maybe they're not going to get all of my life insurance proceeds, because some of it is using to be paid to pay off the house. But now they have the house free and clear, and now you don't have to worry about a mortgage.
Thank you.
You're welcome.
Great information.
Great information. Great questions. Thank you, Angelique. That was a good question. Let me go to Jay. Go back to Jay. Jay, unmute yourself.
Yeah. Hey guys, sorry about that again. The same question I have is that I have an LLC currently in Montana. And it's just for my car. I don't like having cars in my name. So the LLC is directly for that. Now I live in New York. I'm just trying to understand, like, how would I be able to, like, if we own property or what have you, is it better to have it in a state that has, barely any issues with laws, or is it better to have it in New York where we live?
Real estate specifically?
Yeah.
All right. So here's the thing about setting up LLCs outside of your state or operating LLCs. So the LLC that you set up sounds like it's an asset holding LLC, which is different than an operating company, right? So real estate is operational, right? So if you have property, for example, in California, and you set up an LLC in Wyoming because somebody told you didn't have to pay taxes. So you set up the LLC in Wyoming to have it own the property in California. You are now considered as doing business in California, which means that you not only have that Wyoming LLC, but you also now have to file as a foreign entity in California. So now you're going to have two LLCs. So 2 annual filing fees, two registered agents, 2 virtual offices. So it's a mess. People think that, oh, I'm just going to go to Wyoming and not pay any taxes. But if that LLC you set up in Wyoming is operational in another state, you have to file as a foreign entity or you'd be in violation.
Yeah. So my thinking was to keep the cars in Montana, but the real estate, wherever we do it, every property that we own have a different LLC.
That's
right?
exactly what I recommend in Nexus framework is that each property up to a certain point, right? Got to make sense. I'm not going to encourage you to have 50 LLCs for 50 it's just that's going to be a mess. At some point you need to start grouping them, right? And you're going to group them by equity, you're going to group them by property type. So the property should be located in the state where the property is, right? Collecting rent where it's doing business. And then the extra layer, so how I structure real estate ventures is there's a property holding LLC. So these properties hold the LLC in the state where the property is located. And then those LLCs are owned by a holding company.
Yeah.
And then the holding company is owned by the trust.
Yeah. Okay. All right. Do you suggest the same thing for the cars as well? Or I could just keep it as one LLC and keep it a holding company for the cars alone?
You can just have a holding company just for a vehicle.
Okay. All right. That's it. I'm done. Thank you so much. Appreciate it.
Man, this is great gems tonight. Great gems, great gems, great questions. Odara, I'm coming back to you. Unmute yourself.
I'm sorry, I forgot to lower my hand.
Okay, you here now? No questions? Speak now, forever hold your peace.
I'll speak now because why not?
Why not?
I'll go back. I'll go back to that initial question that I asked you about where you're licensed. Does it matter? I actually live in Philadelphia, but will be transitioning and moving over to Georgia fairly soon. So I know you said earlier that you are licensed in the state of Georgia. Does it matter where you live, or does it matter where your assets are as to where the drafting kind of comes in place? I hope that makes sense.
Yeah, and I just want to clarify something. I am not personally licensed in Georgia, but I have an attorney who works in my office who is licensed in Georgia. So just a disclaimer. So that's why we can help in Georgia. And then the second part of your question is, if majority of it really should be where like your assets are, right? So if you plan on moving to Georgia and then you're gonna really have no connection to Pennsylvania anymore, like you're gonna go to Georgia, you're gonna purchase a house, that's where you're gonna set up your bank accounts and stuff like that. It makes sense to just possibly just wait and do it to Georgia. Technically, right? Technically, you don't have to set up in a trust in the state where you live. Like people set up trusts all over the country in different states. But you would have to have some type of nexus to that state, and that's where that trustee comes in. So, like for example, like why people go to South Dakota and they'll get a trustee out in South Dakota because South Dakota laws are really great, although they don't live in South Dakota and their assets are in Georgia. So, so that's the technicality. But my recommendation would be setting it up in the state where you're going to eventually live, at least for the next decade or two.
Go ahead, unmute yourself.
Thank you for that clarification.
You're welcome.
Great questions. Great questions. Shina Diamond, unmute yourself.
I'm trying to get my camera. All right. My question is, as far as creating a trust, would it be possible for one trust to be a sub-trust of another? I noticed in your presentation you mentioned sub-trusts. So let's say I created a trust for myself and a family member, specifically a mother. Would it be possible for me to have my trust to be a sub-trust under hers in the event that.
So, I don't think I'm quite understanding. So you would create a trust for your mom, and then within, if something happened to mom, there would be a trust for you.
Well, I would have a trust set up for a different reason, personal reasons, but I was thinking of a way for any assets she had to be transferred to the trust that I have for separate reasons.
Okay, so then your mom would basically, whatever she has, so I would set up a trust just for your mom. I wouldn't create a sub-trust for you for a different reason within her trust, because that trust really doesn't, again, become activated until something happens to mom. And that, again, those sub-trusts are usually used for minor children, or for people who are beneficiaries who don't know how to handle money well. So basically, I would create a trust for your mom and then name you as beneficiary of everything, but obviously, because you have a trust already set up, anything that comes to you will flow to your trust.
That makes sense. That's what I was trying to figure out. Thank you.
Yep, you're welcome.
Man, these are all great questions, great information. Make sure you guys go to marksetgolaw.com. Schedule your consultations. And Shanice, let's clarify. When they do these consultations, they're speaking to you directly, correct?
Yes, they are. Yep, they'll speak with me directly.
They're not speaking to one of your associates or one of your salespeople or none of that, right?
Nope.
So they get Shanice.
That's right.
Very important, ladies and gentlemen. I just wanted to clarify that for folks who might not have understood that you get Shanice directly. We're at 9:50. I told you I wanted to go to 9:30, but these questions was really good. I see Jose has his hand raised. I know him and his wife is on the road, so this is going to be the last question. Jose, unmute yourself, and let's rock and roll with your question.
So my question is, so we have adult children, and as it stands, we wouldn't want to leave them to any of our assets. We also have some grandchildren. We don't, they're minors. We don't know what they're going to do in life. Can trust be set up that with certain provisions, if they're not met, that it roll over to the next generation, so we don't want to just hand them, per se, the keys to the castle, and they not really doing nothing. They just gonna burn the castle down. That makes sense.
Yeah.
So
that makes perfect sense. So I didn't include the screenshot from that female, that trust that I had showed you guys earlier on the screen, but we do have conditions in there. So there are conditions like, for example, they have to be, drug-free. They can't go to be incarcerated. There are things in there that they have to stay out of certain trouble right there. And then in order for them to receive it, they have to prove to the trustee that they've rehabbed themselves for at least 3 years. So absolutely, you can customize it to however you want. And in fact, if one of them doesn't meet that condition, then the alternative could be, well, if they don't satisfy that condition, like let's say they become incarcerated and they're not shown that they can rehab their character, then their share can pass on to maybe another grandchild. So you may say something like the remaining descendants per stripeys, which is like to the other generation or to the other children equally to be distributed among themselves. So basically they're disinherited because they weren't able to meet the condition, if that makes sense.
beautiful. Yep, it makes perfect sense. Thank you so much.
You're welcome.
Got us open, Matt. Got us open.
No doubt. Let's grow. Let's grow. That's what we here for. Let's
All right,
continue.
yeah, have a good night. Thank you so much.
Stay safe.
Likewise, y'all
All
be
right.
safe out there.
All right.
So this was a very, very educational session. I need y'all to drop some gems in the comments for my girl Shanice. If you learned something here tonight, drop some gems in the comments, please. Make sure you guys, tell them the website again.
marksetgolaw.com. And in addition, I just want to say that in addition to, being a trust attorney, another specialty or something that we specialize in, if I can't help you in that area, if you are a business owner or a real estate investor, that is another area of expertise that we specialize in when it comes to asset protection. So if I'm not in your state to form a trust, I set up holding companies for no matter where you're located. So if you own real estate, if you're a real estate investor, if you're in a high risk industry like trucking, we specialize in making sure that your assets are protected. And again, it doesn't matter where you reside, I'd be able to assist with that as well. So I don't want you to think that, oh, she's not in my state, she can't help me with trust. But not every trust attorney also knows the asset protection for the business side of it, right? So I just happen to know both trust and the business side. So if I can't help you with the trust side, I can certainly assist you with the business side or the real estate investing side and protecting those assets.
Man, it's a beautiful thing, man. Shanice, she is it. I'm trying to tell y'all. I look, I don't share my stage with people who ain't legitimate, who are not bona fide superstars and goats in their own right, and who can't add value to my community. And Shanice is definitely one of those people who adds a lot of value to the community. She is, and her passion, man. I'm telling you, I said this in the um, inner circle mastermind in New York. Like your passion, your energy, like the way you just get into it. Even tonight, like I was watching you on YouTube, right? Just because I wanted to see how it looks from the YouTube perspective of doing this. Because this was my first time streaming from Zoom to YouTube, one of these classes, and like you just like, I don't know, your energy, you can kind of feel it through the TV, you know. Like I wanted to watch you on TV, Shanice. Like it was great, and this was a lot of information. So I I'm really encouraging everybody. Like, how much is your consultation?
So they vary. So if business strategy calls, where we're focused on just like restructuring your business, if you're not even sure if you got a business set up properly, and you're concerned about legal compliance, that consultation is $200. Asset protection. So if you're like in a high risk industry, like I said, like real estate or trucking, that's $300. And then like trust planning, where we're strategizing for what type of trust is best for you and creating an actual visual map for you, that's $300. So they range from 200 to $300.
So what if somebody wanted to book two appointments, right? The trust and the combo pack. What's the bundle price?
I don't, Matt, I don't even have a bundle price. They'd have to book them separately. The 200 plus the 300 if they want to do asset protection and business strategy. But usually they tie, if you are interested in business strategy and like estate planning, I'd say go with the asset protection call, which is the $300 call.
And then you'll discuss everything with them,
That's
basically.
right. That's right. Because we're talking about it holistically. We're talking about asset protection, which is going to include your business and it's going to include the trust. So I'd say go with the higher, the asset protection call, because then we can dive more deeper than just a regular business strategy call
And how long are these calls for?
for an hour.
Let me tell you guys something. No attorney is going to speak to you for an hour for $300. I'm not even going to fucking hold you up. like, like you can't even speak to their secretary for $300. The paralegal, not even for $300 or $200 for an hour. You might get 2 minutes, and you better state your claim real quick because time is money. So, look, I'm telling you guys, everybody here who's watching this, who hears my voice, you need to go to the website right now. marksetgolaw.com. Do not wait. Do not hesitate. Don't even play yourself. Set up your business structures the right way. Because when I tell you, when she gets into the whole holding companies and you got the companies from here, and she was doing the diagrams in the class, and like, just go to her Instagram page. I'm telling you, she's on the chalkboard doing all types of phenomenal things on this chalkboard and breaking these things down. And you get all of this for $300 and you get up to an hour call. It's unheard of. And she is a lawyer, y'all. This is not, she's passed the bar. She has her law license. She is not just an Instagram personality or influencer who's out here putting together a course or doing anything off of things that they might have done or they've read, and now they can just sell and talk and they can teach you it, right? This is someone that can actually help you. and do it the legal way so you're protected. So for the cost of a couple dollars, right? Because most of us will probably spend more than $300 this weekend because it's Mother's Day weekend. And we're going to probably buy food and all types of stuff, which we got to celebrate the moms, no doubt, right? But think about all the other weekends that we spend money on foolishness. And this is something that's here to help you. Then now, obviously, these are just consultation calls. These are not the actual services. Now, once you go and you want to set up your trust, you want to set up your holding companies, you want to do this, obviously, that's going to be more money, right? Because now you're hiring her to do work. This is just a consultation, right? And her IG is The Real Lawyer, okay? REEL Lawyer, okay? I highly advise you, take this hour, take your $300, have this brainstorming session with a professional, get the game, and then execute and set your stuff up. Spend the money because it's only going to benefit you in the long run. Shanice, we at 10 p.m.
Wow.
I don't want to
That
keep
fast.
you here. We've been on here for 2 hours. We can go for hours and hours and hours and hours, right? But I want you to leave them with one final gem, whatever's on your heart.
Oh, what's ever on my heart? You know, don't put off don't put off tomorrow what you can do today, right? I mean, we all think we have time, and I've seen too many situations where just tragic, like, oh, nothing's gonna happen to me, like I'm good, I'm in good health, and the unexpected happens, and it just tears families apart, it depletes our wealth, and it's just like we all think we have time, and nobody knows the day or the hour when we're gonna leave this world. And so you have the ability to make the change today, to be that change that your bloodline has been waiting on, to break that curse of poverty. And so take the opportunity now to do that, and don't wait until it's too late. And when you're on your deathbed, wishing that you would have done things differently because of what, a couple $1,000s that you could have saved. So it's worth it. Your life is worth it. Your children are worth it. Your generation is worth it.
I love it. I love it. Everybody tap in with Shanice. Her IG is The Real Lawyer on Instagram, REEL, right? And then make sure you guys tap in to the website, marksetgolaw.com. Marksetgolaw.com, right? Tap in. Hold on. You muted yourself, Shanice?
Oh no.
Oh, okay. So make sure you guys tap in. So replay will be available for my mentees. I have this streaming live on YouTube for the past 2 hours. You know what? I'm gonna leave this video on YouTube for the next 24 hours. Right? So whoever is watching this now, including my mentees, because I know that takes me some time to upload these videos. If you want to go ahead and watch the replay right now and take notes and everything like that, you can go to my YouTube channel, MG the Mortgage Guy. Everybody can go rewatch this again because I'm gonna leave it up for at least 24 hours. All right. So you guys go watch it. My guys on YouTube, if you just came in, you want to rewatch this video from the very beginning, all 2 hours of it. And then also, everybody, don't forget to register May 13th, 8 p.m. Eastern Standard Time. We got the free masterclass, How to Get $10 in 4 years. We did it on Tuesday, the 4-3-2-1 method. It was phenomenal. We had over 900 people registered for that on Tuesday. Only 300 showed up, which is typical for when you do stuff for free. But a lot of people were hitting me saying they want to, attend the class again. I'm not recording it, so you need to attend. But also this Tuesday, we're going to dig a little bit deeper. We're going to talk about Trump's crushing the Section 8 market, right? We're going to talk interest rates. We're going to talk a lot of different things, not just 4-3-2-1, but we're going to tie it all in with the 4-3-2-1. So I would highly advise everyone to register. Link is in the live chat right now, pinned on my YouTube, and everybody who's a part of the community, I'm going to put it in the community and send it to everybody's emails and announcements and all that other stuff too. So May 13th, or if you go to my Instagram, anybody could just go to my Instagram and comment on any of my posts, DOORS, DOORS, or DOOR, on any post, and the link will be automatically DM'd to you. All right. I want to see everybody there on Tuesday, May 13th, 8 p.m. Eastern Standard Time. This past Tuesday, we went from 8 to 11:30. So this Tuesday, I'm hoping I don't go that long, but you never know. Just like Shanice, I can sit here and talk about this all day, and teach all day long. So this was great.
Thank
Shanice,
you so much. Thank you guys so much.
thank you.
All right.
Everybody, again, go ahead, schedule your calls, your consultations, pay your $300. It's well worth it. And this is tax deductible, isn't it?
It sure is.
Ladies and gentlemen, this is basically a free call for you. Pay your $300. You
Write it
got
off.
you got LLCs, you got all of this. It's a tax deduction. The money that you pay up front, you're gonna make that money back. So don't even worry about the little $200 to $300. Okay. Let's grow, y'all. Shanice, I will be talking to you. Shout out to all my mentees in YouTube. I know I've been depriving y'all for the past 3 months, but I've been busy with my mentees. I'm sorry, but maybe I'll come back next week and put out some more content. Shanice, matter of fact, I'm gonna bring you back on the channel so we can do some conversational type of content. Because there's a lot of things that's going on, just trending news and stuff like that have to do with like holding companies and states and stuff like that. So we're gonna have a real deeper conversation. But I'll spin the block with you later on that.
All right, sounds good.
All right,
Thank
guys.
you,
Yeah,
everybody. Thanks, Matt. All right, take care. Bye.
calls, y'all.